for everyone who are listening or watching us. My name is Yevhen Krapivin. I'm from Ukraine. I'm some kind of moderator of this JTWorld rubrics, and it is our fifth episode. And if we count the episodes during the war in Ukraine, it's the second. Previous was with Marko Milanovic, who is international lawyer from University of Nottingham. And already we have a video in Ukrainian, in English with him on our YouTube channel. So if you didn't see it, please follow to our channel, subscribe, and everything goes there. Today we have again the fifth episode. We are talking about European Convention of Human Rights, about the Council of Europe architecture and the role of Russia and Ukraine in it. And our guest today is Konstantin Zekhtaro and Vasilis Tsevelkos. They are both international lawyers from Liverpool University. And if there is something important that they can add, I think that they can introduce themselves on themselves. Why we stopped on this term, on this topic? Because Konstantin and Vasilis, they are both write editorial to the European Convention of Human Rights Law Review. It's a journal dedicated to European Convention practice, and their topic, their article, we will put the link to it. It is free access article. We'll put a link in the description of this video. So it is article about the interstate case between Ukraine and Russia in European Court of Human Rights. And it will be the main topic of our discussion. But first, I think that we can start from general observations on the situation with the war, with the Council of Europe, and with the exclusion of Russia from or Russian Federation from Council of Europe. And it is a fact that everyone knows it, of course. But my first question will be maybe for Konstantin. Do we see that everything goes to it? I mean that Russia is a very known lawbreaker in international law, and I mean not just Crimea or Donbass war. I mean that in their state, in Russia, they not just discuss on constitutional law level, do they need to execute all the decisions of European Court of Human Rights or not, or they even adopted a law which says that they can do not execute decisions of European Court of Human Rights that are not follows to their national interests and so on. So, Konstantin, can you explain more on this issue and trying to answer to the question that is it logical thing that Russia excluded from Council of Europe, and maybe it should be done in 2014 or even earlier? So please, Konstantin, the floor is yours.
Thank you very much. First of all, thank you for inviting me to this discussion, and I will try to explain what exactly happened in Strasbourg and how the internal understanding of these events, what exactly took place in Strasbourg. So your question is whether it's a logical development that Russia was expelled from the Council of Europe. And my answer to this question perhaps is no, because there are plenty of countries in the Council of Europe which violate the European Convention on Human Rights. There are quite a few countries that resist implementation of the convention, and if all countries were expelled for these violations, I'm sure that soon there will be no countries in the Council of Europe. it's a very difficult question to really scientifically put a precise point when Russia should have been expelled from the Council of Europe, if at all. I argued in 2018 that there are countries which should be expelled, and that there is legal reason for them to be expelled, that statutes of the Council of Europe clearly and precisely provides for the expulsion of members. And I have to say that this is not a rule. Some organizations, they don't have any rules that would provide for expulsion. The Council of Europe does have this legal foundation. But what it means in practice, it means that the country should significantly violate the statutes of the Council of Europe. And what that means is a very good question and a very broad question, because it depends very much on the interpretation of Article 3 of the Statute of the Council of Europe. However, having said that, an aggressive war against another member of the Council of Europe, I think, is a clear violation of Article 3. And if that wasn't the reason to expel Russia from the Council of Europe, my question is, what would be the reason to do that? We have a couple of problematic consequences of this decision, to be honest with you. So, for example, now Turkey sentenced one of the well-known opposition leaders, Mustafa Kavala, to life imprisonment, and his case is pending, will be pending before the European Court of Human Rights. And what will happen next is a big question. So Turkey can be discussed in terms of expulsion as well. However, again, just to reiterate the answer to your question, I don't think that it is if putting it in a different context, if Russia didn't start the war in Ukraine, I don't think that it would be expelled anytime soon. So even what you said, national legislation, even huge human rights problems in the country, I don't think that would justify expulsion politically, not legally, politically would justify expulsion from the Council of Europe. And even now, just to tell you, last week I was at the conference, and it was a quite high-profile conference, and many of the participants were still arguing that it was a mistake that Russia was expelled from the Council of Europe. And the reasons for that are usual. The first reason is very rhetorical: keep your friends close, but your enemies closer. And in fact, that is one of the reasons that it would provide some avenues for dialogue, which I think is a faulty argument, because dialogue doesn't really work in this case. And the second key argument why Russia could have stayed in the Council of Europe is for the sake of people who are in Russia, whose rights are violated. So basically those people whose thousands of applications are still pending before the European Court of Human Rights, and whose applications will definitely be in vain now.
Great, thank you for your answer. Maybe I can ask the same question, Vasilis, but also the additional question in this line, what does it mean for Ukrainians? I mean that Ukrainians now are actively claimed to European Court of Human Rights, because we have this time till 15th of September. And does this last argument that for the sake of Russian people, of human rights, And the same for Ukrainian people and their human rights. Is this argument is strong? How do you think it?
Mm-hmm. Thank you so much, both for the question and more generally for the invitation. With Konstantin, we have discussed these questions extensively, and to a very significant extent, we agree. So, just to answer the first question that you also asked to Konstantin, 3 points from my side. The first is that, and this is we fully agree with Konstantin, we have here a political moment. Russia has been for a number of years been a difficult, in brackets, client, a difficult actor in the cooperation with the court. The dilemma between sanctioning Russia and other countries, the advantages and the disadvantages in this respect, this is something we have been waiting and discussing in the past quite a lot. But now, with the situation in Ukraine, it is, we do have this political moment. It is, if not now, it will never happen. Okay. The second thing is, and this goes back to the idea of this dilemma: shall we sanction or not? There is a trade-off here, because the question here is, who is really sanctioned? Who is really being sanctioned here? Is it the regime? Is it in international law, we tend to think of the state in very abstract terms as one single entity. But a state is a very complex entity, and behind the state, or the basis of a state, is always the people, the population. And the people, the Russian people, they are also the victims of human rights violations by the Russian state or by other states as well. If Russia is sanctioned, then they cannot access the court. So who is really being sanctioned? And this is a broader question in international law. It goes back to the idea of smart sanctions. So sanctioning a regime without really affecting the population. And the third point in this respect is that we are, in a sense, navigating through uncharted waters. And what I mean by that is that we don't have any solid practice. This is not the first time that a state is leaving the Council of Europe. This has happened with my own country, Greece, in the past, when Greece was under a dictatorship, so you had a dictatorial regime. There has been the Greek case against Greece, an interstate case. And Greece, when they knew that they would be, in a sense, called to withdraw from the European Convention of Human Rights, they decided at the very last moment to, when they knew that they would be sanctioned, they decided at the very last moment to withdraw. But this was in the 70s, mid-70s. Now we are in 2022. There is no practice. And as Konstantin said, there are practical implications. And one of them is that Ukraine now shall be in a rush in order to apply before the European Court of Human Rights, collect all the evidence that might be necessary. And we are talking also about an ongoing situation. We don't know what will happen in the months to come, unfortunately. Things might, get better. So just with regard to the other question, this time limit makes the job of lawyers and whoever else will be involved in this case even more difficult. On the other hand, there is still an opportunity. This is still something that is available. I'm not sure, and this is another question we might discuss. This could also be a question to Konstantin, maybe, how effective, and this is what we discussed also in this editorial note, what is the value of an interstate case? What can a court like the European Court of Human Rights, which was created for a different purpose, and primarily to support claims or to decide on cases of a different nature. What can it really do? We do have some practice in this respect. And on the one hand, you do have examples of judgments. On the other hand, you do also have examples of difficulties in the execution. So the practical effect can be limited in this respect. Nevertheless, this is an avenue that Ukraine might wish to explore every right, both legally and morally, if I can also become a little bit more personal in this respect.
Yeah, I can only agree with what Vasily said, but to put this a little bit in perspective, if we want to talk about the effectiveness of these applications, then it will very much depend on how the situation develops politically. So now, if the situation freezes for next, hopefully not, but if it freezes for next couple of years, as it is, Russia will not execute anything. They will not participate in any of the cases in Strasbourg. They will not reply to any memoranda. They will not execute anything, as I said. So, of course, it is good, as Vasily said, for the lawyers in Ukraine to try to rush and to apply to the European Court of Human Rights. Yes, if they just want to have moral satisfaction of submitting the claim. If they want to get anything out of it, it is a gamble. It is a gamble which depends on the political situation. Now, we know that yesterday the Russian parliament started considering the law that would actually effectively stop the I think that is one of the participants also talking in the chat that started introduced the law, the statutes that prevents the prosecutorial office of Russia from communication effectively from, it's more complex than that, but effectively from communicating with the Council of Europe and with the European Court of Human Rights. And as far as I know, in practice, they have already stopped replying to the Council, to the ECtHR anyways. Now, that means that all these complaints that are now pending against Russia will be more or less a memory exercise, an exercise that at some point the court might want to come back, a historical archive kind of thing, rather than effective legal mechanism. So I don't see too many avenues for effectiveness as a unless the situation changes significantly on the political arena.
Yeah, thank you, Konstantin and Vasily, both for answers. So, you know that when I mentioned Ukrainian lawyers, and I think that it's logical that everyone tries to find all legal ways to influence on Russia. And now we'll have some very intensive work in civil cases. I mean that everyone understands that Russia will not answer for the crimes in the way that it mentioned in civil legislation, but we see the Russian property outside from the country, which is frozen, and these assets, everyone wants to get to it, to reach them, and some logic here exists. So it's the same situation with European Court of Human Rights, because previously we saw the results of its work, its influence on Ukraine, and still people are really waiting for the results, for the efficient mechanisms. But nevertheless, we're going to the interstate case, because you know, in Ukraine we are mostly talking about some criminal mechanisms like International Criminal Court. We are remembering International Military Tribunal in Nuremberg. We are talking about the experience of Yugoslavia and Rwanda tribunals and so on, because everyone understands war crimes, crimes against humanity, genocide. It's all have dimension in these institutions. But the human rights topic are in some shadow, are hidden from discussion. And I think that, well, I understand why, but maybe one of the answers is that we do not have enough knowledge of these mechanisms that European Court of Human Rights gives us, because we know individual cases against country, but in Ukrainian experience, in Ukrainian legal history, it's not a lot to speaking about interstate cases. So my question again for the Konstantin, you mentioned three obstacles, three threats which are can stop this case, which can lead to the fail of the case. And can you explain, first of all, how do these mechanisms of interstate cases work? And the second, your opinion on Ukrainian perspective based on these obstacles that you mentioned in the article, please.
Now interstate cases indeed in history, like if we look into how the convention was drafted, interstate cases were first compulsory part of the court's jurisdiction. So even before the court could, the states in the beginning could agree or disagree to allowing individuals to apply to the European Court of Human Rights. But if they accepted the jurisdiction of the court, they couldn't prevent interstate cases to appear in the court. So that was, in the beginning, a more normal way of submitting applications to an international court. And Vasilis, of course, will correct me if I'm wrong, because he is more on public international law side of things than me. But in international law, individuals are, at least in the 50s, when the convention was drafted, individuals were very rarely seen as, subjects of some capacity, so to speak. They couldn't do much on the international. It was international organizations and states, abstract states, that could do something in the international level. So these individual applications were a bit weird to begin with. Now we know that these individual applications were the fuel behind the European Convention of Human Rights and the European Court of Human Rights. And although there were a few interstate cases in the beginning, by the 90s, the number of these interstate cases almost went to zero. The states didn't feel the need to bring the application to the European Court of Human Rights. However, with the increased number of conflicts between the contracting parties, we have more and more interstate applications. And I think that there are 10 or 11 applications only from Ukraine against Russia at the moment. There were a couple of applications of Georgia against Russia, and we had the judgments of the court in Georgia versus Russia #2, which is a questionable and problematic judgment, and we can discuss it if we have time. We also have a couple of pending applications of Armenia against Azerbaijan, Azerbaijan against Armenia, and in relation to Nagorno-Karabakh, but also there is an application of Russia against Ukraine that was submitted a few months before the war. So what are the interstate applications? Interstate applications are complex. They are extremely difficult to in terms of evidence, and especially in terms of evidence when the ongoing hostilities are there. Basically, it is very difficult to prove each individual aspect of a particular complaint. Also, the difficulty is that the respondent state needs to somewhat collaborate with the court, because otherwise there is no major point in dealing with this interstate application. Another problem is that interstate applications actually are usually assign for many more individual applications which are tailing, like connected to this interstate application. And if the court delivers a judgment in the interstate application after 10 years, these all individual cases are frozen in the meantime. Right? Like in the case of Georgia versus Russia, all these individual applications connected to the interstate case were kind of frozen. And that is also a problem. We all know that the time that the court spends on interstate, on judgments, on the cases in general is extremely long. So what one would expect as a result of this application? Well, one of the, I think two applications, interstate applications of Ukraine versus Russia are in a more advanced stage. The one in relation to Crimea, I think they could manage to deliver the judgment by 15th of September. I don't know, but it is perhaps possible. But in relation to all other applications, it is very difficult practically how to deal with them in Strasbourg. One thing is that there will be no Russian judge. There will be no, so this can be sorted out. We know that in one of the applications recently, no judge was available from Russia, and the president of the section just appointed another judge in this case, elected in respect of Cyprus to act on behalf of the Russian judge. This is questionable from the convention point of view. There are plenty of other technical issues that the court simply cannot rule on the basis of application of the argument of one side, right? It's a competitive procedure, adversarial procedure, and it means that the other side at least needs to provide certain arguments against what the allegations are. And if there is response is not there, the legitimacy of the judgment will decrease. So that is another problem. To cut a long story short, indeed, it is difficult to see. Well, it is possible to imagine that the European Court of Human Rights will deliver judgment in all these interstate cases. It's not beyond possibilities, right? It is quite possible. However, again, the key question is what impact these judgments would have, and especially what impact this judgment would have when Russia, the respondent state, did not at all participate in any of the proceedings. Most likely they will say that we were not there and therefore we don't feel obliged to comply with anything that comes from Strasbourg anymore.
Yeah, thank you, Konstantin. Well, I share your skepsis on Russian position because they deny everything in terms of international law, and it will be no surprise, and it's very prognozable position on this interstate case. In any way, Vasilis, I want to hear your opinion, and also from perspective of specialists in international public law, because again, this transformation from interstate to individual cases are not known enough in Ukraine for Ukrainian audience. And if you can explain this and and also perspective in Ukrainian case, we will be very glad. So please.
Yeah, thank you so much. So from my side and from a more public international law perspective, just I could divide it in two parts. The first one is the practical difficulties that Konstantin mentioned as well. I think that to understand this, I'll be giving just a very silly example here. We are in a situation of imagine someone has been working for an employer. The two parties are not happy. And then the employer says, I'll fire you. And the person says, well, you're not firing me. I'm quitting my job. I'm resigning, okay? So Russia is very clearly not going to cooperate with the court until at least the regime changes or the situation fundamentally changes from a political perspective, point of view. So now with this in mind, then it is very clear that we have practical difficulties. One of them is in absentia, okay? Russia is not going to cooperate. And you have a number of gaps that this is creating with regard to the rules of procedure and the evidence, who will be the sitting judge, etc., etc. But then you have the biggest problem, which is implementation. And this is a problem that you would have one or another way. I mean, even if Russia remained and it was willing to cooperate with regard to the process, then when we would reach the point of the execution of the judgment, things would still be very difficult. Why? Well, think of other instances, the Cypriot cases, okay? Cyprus versus Turkey. And you have both interstate cases, but you also have, as Konstantin said, a number of individual applications. So which are, we would call them as quasi-interstate cases. You have one individual who complains about the situation which concerns the broader population, okay? It is the political dispute between two states. These judgments are now more than 20 years old, and still they haven't been implemented. In which dimension of them? The land, the return of land, okay? When you go to a court, like in particular the European Court of Human Rights, you want to achieve two things in these types of cases. One thing is reparation for the victims, life losses or material damages, etc. These, to some extent, it can be achieved. Let's say if the state against which the judgment has been delivered is willingly to cooperate. But then you have the biggest issue, which is the return of land. And so far, no interstate case has ever managed to be successful in this respect before the European Court of Human Rights. Okay, so this is the first point. Second point. Nevertheless, so I'm giving you a picture which is not very optimistic. Nevertheless, states continue to employ this avenue to go before the European Court of Human Rights and other similar quasi-judicial instances before the UN system, for instance, the UN Human Rights Treaty body system, and they try to reach a decision, a judgment, whereby the state is found to be liable, to have violated international law. So why they do this? Why? Well, the answer is it has a declaratory power, it has a symbolic value, and this is the idea of lawfare. Instead of going to warfare, instead of fighting with wars, with arms and troops, it is better to go before an international court. Now, why this is problematic in international law and why states prefer the European Court of Human Rights? Well, my understanding is that to a large extent they do this because there are no other alternatives, or the other alternatives are very limited. And let me unpack this point. International law relies on state sovereignty. States are sovereign, they are the ultimate authority over a territory and the population. No court has jurisdiction, has power, has competence over a state unless the state agrees. This explains why, for instance, the International Court of Justice, which would be the natural court for this type of dispute, is so difficult to establish its jurisdiction and to go directly straight to this court and say, well, another state has violated the UN Charter. They invaded, this is aggression, this is armed attack, they are in breach of international law. Ask them to go back and to, restitute the situation. This is not easy to happen in international law. Why? Because the precondition is that the other state has recognized the competence of the court. Well, the European Court of Human Rights is a court that has competence over all 46 now states of the Council of Europe. Still Russia, but in a few months' time, this will not apply. And why this is the case? Because when they designed this system, outside of individual applications, which, as Konstantin said, it was a true revolution at that time. You had an individual, you had a human being, a human person like us, or an individual entity that would sue before an international court a sovereign state. This was a revolution. Outside of that, they designed the system, and this became, in particular after Protocol 11 in the mid-90s, compulsory, the jurisdiction of the court with regard to interstate cases. So this is an avenue that can be employed by states in order to sue another state. The problem is, or the problem, in brackets the problem, the issue here is that the European Court of Human Rights can only deal with human rights cases. If the Ukraine would go before the European Court of Human Rights and they would say, well, Russia has violated the UN Charter, or they have violated general principles of international law, the European Court of Human Rights would say, I have no competence to deal with this. Can you tell me something on the basis of the European Convention of Human Rights? So we take a war and we turn it into a human rights dispute. And this makes it even more difficult. That's from my side. I mean, any follow-up or something that has been unclear, just let me know.
No, everything clear. So I just thinking that, of course, after World War II, the question of convention was not a question of war, because it was another institution like ICJ or tribunals. And I agree that it was revolutionary when individual in practice became some kind of subject of international law, because he can claim something towards the state on his own without any additional support, and fully agree with that. But again, our topic today based on Council of Europe architecture, and we discussed about the court, and we know that of course Russia was excluded from other bodies of Council of Europe, and for exclusion from the Parliamentary Assembly was not the first one, the second one. And the question to both of you, what are the mechanisms of Council of Europe we can use? Because again, Russia is not, for now, it is not a member of Council of Europe because it was excluded, but still some mechanisms can be driven, can be enforced. And can you make some examples of what can state of Ukraine as a state or Ukrainian lawyers can do in this situation?
Well, if I can kickstart that's basically the idea is the same as Vasilis actually mentioned. It's very difficult to apply any rules to the country which is not a party to the organization. And that goes back to the sovereignty point that he made, and the state is free to agree to limit their sovereignty and allow an international organization to somehow interfere with certain aspects. And as soon as you leave, you stop being able to do that. So that is one of the arguments against Russia being expelled, which I think is a faulty argument, because Russia wasn't really keen to collaborate with the Council of Europe in general altogether. And this piecemeal of collaborations, or as some academics call this an a la carte implementation of the convention or other conventions. This strategically, on the one hand, show that Russia is still collaborating with the Council of Europe. It's still the party to the European family of states and still made an impression of a civilized, in inverted commas, nation. But at the same time, in substance, it was deteriorating to dictatorship. You know, so I think it is fairer and more straightforward to be clear that we have no, well, on the one hand, we have absolutely no impact on Russia through the Council of Europe, but at the same time, Russia cannot use the Council of Europe to window dress what is going on there. Now, what's, well, Russia is still a member of the Organization for Security and Collaboration in Europe, and we know that the Moscow mechanism was initiated in relation to Russia, and there were a preliminary report published already, I think, but again, that was highly criticized by the Russian Federation. So to answer specifically to your question, that there are very few avenues, if any, that people can use through the Council of Europe to influence the Russian Federation at the moment. I don't know, like the Venice Commission can do something, perhaps draft yet another report on yet another law that is completely against all possible human rights standards. But we've seen the same thing in relation to Belarus to no effect whatsoever. So unfortunately, and I argued that in one of the articles that I published last year, unfortunately, we have to say that often we cannot expect an immediate effect from international law at all. The effect might come 10 years later. The negative side of it is that 10 years later, it might be much less effective than at the heat of the moment. But at the moment, we cannot expect more. Why we cannot expect more? Because of S word, because of sovereignty. And this is the fault of these rogue states like Russia, as much as highly so-called, law-abiding states, like, for example, the United Kingdom. None of them are willing to sacrifice their sovereignty. Why? Because there is not enough, trust between states. And events like war in Ukraine obviously do not increase this trust. And therefore, unfortunately, unless there is a major catastrophe like the Second World War, and I'm not too sure that we will survive over the Third World War, but there should be a real shift in trust on the international level, which I cannot see happening at any time soon. Vasilis will be happy. I will be happy if you disagree with me on that point.
No, I don't disagree. And just to add, going back to the question that we asked to answer, I think that an international organization like the Council of Europe, to exercise its functions and competencies, some of them require the collaboration of the state. So let me give you a concrete example. CPT, the European Committee for the Prevention of Torture, to visit prisons and see prisoners and visit and monitor the situation in, for instance, prisoners of war. This cannot happen unless the state, Russia, is willing to accept the agents of the organization on its territory. But there are other functions that do not require collaboration, and they can be, from a judgment by the European Court of Human Rights, which produces legal effects, but then it's the problem of effectiveness, to mere political declarations, to apply pressure against a regime and to show who is the victim and who is the aggressor in this case. So there are still some things that the Council of Europe can do, but many of them will just have a symbolic or declaratory value, which I don't underestimate it. I think it is important, and I think that they point in a direction, and they do have a value, but they are not a solution to the problem.
Yeah, thank you. Thank you for answers. And Konstantin mentioned Moscow mechanism report of OCCI. And I really see some kind of hypocrisy in Russian reaction for it, because they positively evaluate OCCI actions. I mean, in Donbass conflict and in Donbass armed conflict, and now they just changed their mind on this organization and their reports. So. I have some additional questions about international security architecture at all, but I prepared them for the situation that we do not have evidence, and now I see a lot of participants, and it's really great. So I think that we can go to the evidence, to their questions, and maybe after them, if we have time, I'll ask some general questions about international law. So please, if anyone have will to ask, I invite you to do this.
Arkady, talk to us.
Yeah,
I know that
we
you
see
have plenty of
Arkady.
questions.
And we know who is Arkady.
Who is indeed, yes.
Yeah.
Hi.
Good to see you.
There are so many smart people. I don't know what I can add to what was said now. I really, yes, I'm a little disappointed with this exclusion of Russia from Council of Europe. Yes, as a Ukrainian, I've felt some satisfaction from such a very brave act of the Council of Europe, because now Russia is our enemy. But in the long run, I don't know what would be the consequences. I heard all the many of the considerations. It sounded now in this discussion, and I suggest that Council of Europe took it into account when decided on the. I suggested it was a painful decision for Council of Europe, but yes, we have some technical problem with some application to the European Court against Russia, and so on and so on. But it's not the most important thing. I think because many Ukrainian lawyers applied or assisted to apply to the European Court of Human Rights against Russia for some destruction of buildings, houses, and so on and so on. But from the outset, I didn't consider European Court as an appropriate mechanism for such an action. I suggest that European Court is more useful in dispute with our own state, and in developing some legal culture inside the state, because these possibility to involve some foreign state for to punish some foreign states for some losses in Ukraine. Maybe I don't know. I know that there is a huge application about this destruction of property before the European Court of Human Rights, and I don't know the fate. I suggest that European Court doesn't know exactly how to deal with these cases, because there is many questions, some legal questions about how to decide it. But in long run, I don't know. Yes, it's an avenue for dialogue. I understand that Russia is very unwilling to be honest in this dialogue and to be really involved in this European culture, and they try to resist all this and to lie, to provide some fakes about situation in Russia. But in any case, it was a dialogue. I know, I know, and I suggest that Konstantin knows very well what the problem that, for example, Belarus is not a member of Council of Europe and a member of European Courts of Human Rights. It's more difficult. I know. I am a lawyer, and I always understand the European Court as an effective instrument to solve some problem inside the country. For example, Belarusian people have less instruments to solve the problem in their own country. Now, Russian people also have less instruments to solve the problem and to develop some legal culture. And you know, it was very painful act for Russia. They now, it's not the situation when some organizations, some good guys, just not accept some bad guys that. Some alien guys that they don't accept it. Now Russia is a, how to say, fallen angel. So it was expelled from the good company, and I suggest it just would be a fuel for some. Development of their own culture, and some resistance to European values, because they're fallen angel, and you know what is the second name of fallen angel, and I don't know. We'll see. I understand that maybe the behavior of Russian Federation cannot be tolerated by the Council of Europe, and they were forced to take some decision. But we'll see. I don't know. But in any case, I suggest that hopes about the ability of the European Court of Human Rights to solve the problem that stemmed from this war. These hopes are very exaggerated at the outset.
Thank you, Arkady. Konstantin, Vasilis, do you have some reflections?
Yeah, if I can, Your Honor obviously is always right, but I have some disagreements, as we can say. No, I agree that all the hopes that this conflict will be solved in Strasbourg are exaggerated. In Strasbourg, I mean in the European Court of Human Rights, they cannot be. Now, the second, like, and I kind of disagree with the bigger picture analysis that Arkady just provided. Okay, Belarusian people didn't have an opportunity to go to Strasbourg in 2020, in August, when the revolution was, like people were beaten and tortured, etc. You all know what happened in Belarus. Now, if this was happening and the Council of Europe, the Belarus would be the party to the Council of Europe, whether that was any different, I'm not too sure. We can see that Russia was effectively deteriorating in dictatorship while it was the party to the Council of Europe. So I don't think that there is a very significant correlation between being a party to the Council of Europe and being democratic. It's quite vice versa. It's you are democratic and then you become the member of the Council of Europe. We can also look at, I don't know, the UN Human Rights Committee, and UN's human rights protection system is utterly depressing and utterly useless, my personal opinion. But you can look at UN Human Rights Committee communications, and when these communications are directed to Norway, they are always implemented. When they are directed at Belarus, they are never implemented. You know, so it doesn't really matter where you are. It's what matters is how these instruments are perceived on the ground, right? And if they are perceived as non-devote of any legal value, then it will have no legal effect. So I think that it was an only right decision, and I kept repeating it many, many times, to expel Russia from the Council of Europe. And I think that it could, and coming back to Evgen's first question, it probably would be more fairer to expel Russia in 2018 or 2014, when the first aggressive war happened against Ukraine, or even in 2008, when Russian forces occupied part of Georgia. So that is my slight disagreement with overall major agreements of His Honor.
Yeah, thank you, Konstantin. I think that you repeated some argument which Eric Posner, who is son of Richard Posner, a famous American lawyer, he said that the number of treaties, of human rights treaties, the number of human rights organizations in which country participate are not dependent on the level of human rights observation. So it's different things, and you can sign everything like Soviet Union, but it's just a piece of paper. And he called it the, how do you call it? The downfall of human rights, or the twilight of human rights. Okay, so
Twilight,
it's like
yes,
the twilight of human rights. So it's something like that. And Russia is a great example. And Eric Posner, he mentioned Russia a lot in this book. Okay, so Vasilis, can you add something?
Can I just jump in on that point? Yes, very, very quickly? Just two examples again from the article that was published in European Human Rights Law Review. One is about Turkmenistan. Turkmenistan actually ratified every single UN human rights treaty in existence. Every single one, more than the US, UK, France, any other country. We all know
they do like human rights.
They do like human rights on paper, not on the streets. Like Stalin's constitution that had quite extensive list of human rights at the moment, and we know what it led to. Okay, I'll keep quiet and let Vasilis disagree with me, especially on the UN point. I'm sure that he has something to say on that.
Okay.
Okay, yeah, thank you for these comments and thoughts. Well, with regard to the United Nations, a more general point. I mean, we need to situate things in their environment, and the environment is always political. And 47 European nations is not the same as almost 200. I still see a lot of usefulness in the UN system, but it is a different animal comparing to the Council of Europe and the ECtHR system. It is a very big discussion as to how effective it is, how it could be improved, etc. But it is contributing, and I think it is offering. I mean, the overall contribution is positive. So it is better to have this system than not having it. Now, with regard to both points, I mean, both by Konstantin and Arkadie, if I'm not mispronouncing the name, 3 points. The first is I fully agree with Arkadie with regard to the importance of the will by states to comply. And this would apply both to the UN system, the European Convention of Human Rights, Security Council, criminal law that we discussed earlier. This is a major aspect, a major point. Why? Because we are lacking enforcement mechanisms. Okay, if within a system you have effective enforcement mechanisms, then the legal tools like the European Convention of Human Rights and its system, they can do their job and it will be effective. If you don't have effective mechanisms, then it depends on the will of the players to cooperate, to comply. And of course, this is a very political game. Now, this brings me to the next point, where I think that this is something that we have discussed with Konstantin extensively in the past, before the situation and the aggression against Ukraine, as to whether it is better to have Russia within the Council of Europe or outside of it. And in this respect, I must admit that I respect a lot this sort of skepticism by Arkadie. I mean, these are thoughts that I'm also having. I told you at the beginning that this is a trade-off. You win something, you lose something else. Overall, I don't know if it is better before the situation in Ukraine, okay, before the aggression. Overall, I don't know if it is better to keep states like Russia, like Azerbaijan, like Turkey, just to name 3, but there are more states. You have this concept of democracies rising in Europe, etc., etc. I don't know overall what it is better, if it is better to keep them in the system and try to apply pressure, get even the tiny little bit that they will cooperate, that they will be willing to give, or better to say, no, you stay out, we cannot pretend, we cannot just, it is fake. You do not share these fundamental values, so it is better that you stay outside, and if things change in the future, then we can revisit the situation. I very honestly don't know, and this is the point we have discussed with Konstantin. I'm not even convinced this is the job of lawyers. I would need insights from political scientists. You mentioned Posner, so law and economics, game theory. There are other methods, other tools that they can tell us whether overall it is better. They can quantify the impact of the institutions on the internal domestic legal order of a state, and they can tell us, well, is it worth it or not? I don't know. Very honestly, I don't know. And the last point I wish to make is that I am fully convinced that it is the right decision to expel essentially Russia after the aggression, after the invasion against Ukraine. Although I just admitted that I'm skeptical and I'm aware of the limits of my own methods and tools as a lawyer, for a very simple reason. I think that systems like the European Court of Human Rights and the Council of Europe, they rely on a common minimum ground. These systems were developed after World War II just to avoid having these situations. Now, they evolved, and we can discuss how many days of paternity leave we should have in Russia, the case law of the European Court of Human Rights, but this is a luxury. This presupposes that we have those minimum common understanding, common standards. This is the very reason why we had the Council of Europe. Russia went clearly against it. It is not the only state, but at some point we need to say, well, this is it, no more. This is a red line we cannot cross. And I think that I'm not saying that this is a universal reaction, but the Western liberal democracies are reacting very clearly, and they are setting this red line, and essentially Russia is excommunicated. You see the Human Rights Council, they are no more, they have been, thrown away. I'm not using legal language here, I'm using political language, but this is essentially what happened in political terms. And the message is very clear. I mean, this is a red line we are not willing to tolerate to be crossed.
Yeah, great. Thank you for your answer. So I have a lot of reflections, but I see that we have not so much time. So maybe our audience have some another questions. Please, it is your opportunity to ask. If or not, even if you're not, I say my reflections. So. Of course, it's like not just a legal discussion; it's also political discussion. I mean, this pro and cons about the Russian exclusion from Council of Europe, and as we see in Ukraine, of course, it's some satisfaction, some moral satisfaction that bad guys are excluded from this very important or generous organization. But of course, for Russians, for our possibilities to defend our human rights, it's not so good step. And I think that again, we can discuss it is good or bad because it's pro and cons. But to make some conclusion to end our discussion, I again ask both of you, how do you see a new architecture of human rights defense in Europe? I mean, that Russia still be a huge country on the European continent, and we still need to cooperate in some kind of this regime on the next one. And do you see maybe some return to Council of Europe, or it will be some alternative organization? Maybe Russia will propose some organization like the collective defense mechanism they have with Armenia, Kazakhstan, Belarus, and so on. Maybe they will create their own human rights organization. So how do you see the future of this mechanism? Because everyone now discussing about the new UN agreement, maybe about the new infrastructure of United Nations, I mean, Council of Defense, but Council of Security, sorry. But for Council of Europe, will it be some changes, or you see that it will be just Council of Europe but without Russia, like without Belarus or without Kazakhstan or other post-Soviet countries that are more authoritarian and goes to dictatorship but not to liberal democracies? Please.
Do you want me to go first? Okay, yeah. No one can really tell. One thing is that we will need some time so that now it is the heat of the moment. We will need some time. We will need to see how things evolve, etc. We don't know what the political repercussions of the situation will be. We don't know if this war will escalate, if we will have a broader, I wouldn't want to call it World War III, conflict, or if, we don't know how this will affect the so-called globalization. We don't know anything yet. But if there are to be changes in the institutional architecture, I would say that the Council of Europe will be less involved than other institutions. And this for a very simple reason. The Council of Europe, and in particular the ECtHR regime, they are working quite effectively comparing to other systems, other regimes, etc. And they have a much broader role and function to perform outside. I would even say they were not designed for situations like Russia and the invasion against Ukraine. They were designed with the idea that we'll have no other war. We are European states, are liberal democracies, and let's see how we will cooperate, how, let's say, integration, common standards, etc. The European Court of Human Rights and the Council of Europe have been quite successful in this respect, and I see no reason why they should not continue performing their tasks, etc. Now, if we have no further escalation, I would risk saying that the impact of this war on the broader international institutional system, again, will not be so big. But we might have economic consequences. We might have, in terms of diplomatic relations, strategically how, new groups of states will be formed, etc. But institutionally, I don't think that if things stay the way they are, they will affect the UN system or any other organization at the global level. But we don't know if the situation will escalate, and so we cannot tell with certainty what will happen.
Okay.
I generally agree. I will try to be very brief. I generally agree with Vasilis here, and I attended the public lecture by the president of the European Court of Human Rights, Judge Spana, last week. And I asked him the question of what lessons the court learned and as a result of the Russian expulsion, what actually, how they will change their work in the future. And he told me that, well, not only me, but everybody in the audience, to be honest with you, that he cannot answer this question. They're still reflecting, they're still figuring things out. They are not sure what's gonna happen. It is, and generally, President Spana was quite unlucky during his very bumpy ride of a president, because he started his presidency and 3 months later, the COVID pandemic started, and then the war in Ukraine. So his tenure was really, really problematic. But what happens next? I think that it is not impossible that the Council of Europe will be 47 states again. We know that Kosovo just applied to be a member of the Council of Europe, and Russia out, Kosovo in. I think it's a very strong slogan. But otherwise, we know that the Council of Europe, as we know it, exists only for about 30 years. It existed before, and it will continue existing after Russia is expelled. I don't think that we should overestimate this event, but also we shouldn't underestimate it. I think that Russia can come back, but this will be not a legal issue, it will be a political decision. And obviously, I think that the Council of Europe can put conditions to this return. And these conditions would be obviously execution of all the judgments of the European Court of Human Rights, including UCO's judgment, which hasn't been executed, including Catan judgment and all other judgments of the European Court of Human Rights. that were not executed by Russia. But these are the considerations for another day. Now, I think the fact is that Russia is outside, Russia is not the member, and Russia will remain the member, will remain not the member of the Council of Europe until the current government is in power in the Russian Federation.
Yeah, great. Thank you for such answer. So I agree that right now, at the moment, we cannot prognose anything because, you know, on 24th of February, I have a lot of thoughts about international law and so on. But now we just have some points that we discussing today. So I thank you both for participation in this discussion. I thank you for all the participants, and we'll share this video maybe with Ukrainian subs, maybe not, maybe prepare some materials. So it will be available not for English speaking audience, but for Ukrainian speaking one. And of course, I think that it's not the last meeting of us, and we will have some point to discuss, maybe during the war, maybe after the war, and to look on Council of Europe architecture, how does it influenced by war in Ukraine. So again, thank you for everyone. Have a nice evening. And see our JTWorld episodes in future. Thank you.
Thank you very much. See you later.